related to human genome editing. My name is Jennifer Merchant and I teach at the University of Paris. I just have a few slides that can just be looked at while everybody is getting settled. And before I call our speakers, our panel is the biggest of the day, I think, of the entire session, of the entire conference. So I'm going to ask my colleagues to be brief and to respect the 10-minute delay and save the time afterwards for your questions, because you might have a lot. The objective of this panel is to give a brief snapshot of international law governing somatic and germline gene editing across the world. So here you have a map that more or less shows you the international regulatory landscape of human germline gene modification with the legend in color. Now, I'd like to say that these slides are, of course, going to be available to everybody, so I'm not going to get into the details. And the next few slides that you will have available for you is the list of recommendations, advisory reports, and committees that have come into being since the last summit in 2015. So there's quite a lot of information to be found from various countries, from the Netherlands, from South Africa, from the German Ethics Council, from India, from the European Federation of the Academies of Medicine, etc., etc., etc. Of course, you will find also the references to the NAS report that we published in 2017, as well as the latest Nuffield report, as well as the French Comité Consultatif National d'Éthique report, the report from Australia. There are therefore 5 slides for you to find all of the resources that have been published and have communicated on this topic of human genome editing. So it's a valuable source for everybody. So I'm now going to turn the floor over to our first speaker. And like I said, this is just going to be a very brief overview of the international landscape. And we don't have every single country represented here. We're first going to hear from Ms. Xiaomei Zhai, who is from the Chinese Academy of Medical Sciences at Peking. Ms. Zhai.
Thank you. Because the biggest panels, I will follow the rule strictly. So I will use 8 minutes or less. So I would like to talk about 2 things. One is our Chinese framework, a regulatory framework. So actually, there is an extensive regulatory framework in place in China. Briefly, this includes relative rules. The interim procedures for human genetic resources management promulgated in 1998, revised 2016, and ethical principle on ART, artificial reproductive technology, and the human sperm bank in 2003, and especially the Article 9, and also the ethical principle on human embryo research, especially Article 6, and the GCP in 1998, revised in 2003. And the ethical review of human biomedical research involving human subjects in 2007, revised 2016, and also recently. And the regulations of management on human genetic resources management, 2012. And the regulations of management on biotech research and development, 2017. And the Chinese regulation already banned genetic research for reproduction purpose. Both before and after the publication of the experiment, there has been an intensive public debate about the ethical issues raised by such research. And after this discussion for the cases, and we have a consensus for the ethical groups. And the one is the ability to genetic editing raises a number of very challenging ethical and policy issues. So ranging from safety concerns to the consideration of the implication of human germline genetic modification. So we need to provide guidance regarding appropriate oversight and ethically acceptable modes of the pursuing this research, thereby reducing the likelihood that will result in obstacle to ethically and scientifically defensible research, and facilitate formation of the proper policies for research. And oversight structures must be in place prior to any attempts to conduct this research for the purpose of human reproduction. In considering policies governing this regulation, the regulation of application, the distinction should be made between objections that are based on technical or safety concerns and objections that reflect other moral considerations. So for technical and safety concerns have the potential to be resolved over time by additional scientific research and advances, while the other moral consideration may continue to be the focus of public debate. Public policies carry great power to facilitate or restrict scientific exploration in the area of biomedical research. So policymakers should pay careful attention when regulating science. When enacted, policies governing science nationwide and internationally ought to be flexible so as to accommodate the rapidity of scientific advances as well as change of social values. So society have the authority to regulate science, and the scientists have the responsibility to obey the law. However, the regulations should not just be based solely on divergent moral convictions. Any interference with scientific inquiry should be derived from the reasonable concerns about demonstrable risk of harm to persons, societal institutions, or society as a whole. In the case of genetic modification or genetic editing, as with all science, it is important to target policies specifically to those dimensions of the research or its applications that have the proved to be ethically unacceptable. These policies should be proportionate to the magnitude of what is morally at stake. That's all. Thank you.
Thank you very much, Jaume. Now I'd like to introduce Hervé Schnavis from the Centre National de la Recherche Scientifique. He is also a president of the French INSERM Bioethics Commission and was previously member of the French National Bioethics Commission.
Thank you. I'd like first to thank the organizer for the invitation, and I'm going to speak about two topics today. One, the work of the institutional committee in France, both at the level of our National Health Institute, but also I will give a few words on the revision of our bioethics law. We are revising our bioethics laws every 7 years, and it will be the case the next year. I will also give you a few words about ARIGE, an international organization we are involved in. To start with the INSERM Ethics Committee, this started in 2015 in the framework of consideration at the international level. You had HEROES, the head of the Institution of Research meeting in Canada in spring 2015. And in our first opinion, it seemed to us immediately important to distinguish at least 3 eras or 3 topics associated with different issues. And I think that we need absolutely to have systematic views, not only too much focused on only one or another application. First, it was clear that the first field was the application of the technology to humans, which essentially raised the question of germline modifications. 2, the application to human and plants that might finally apply to humans too. And this raised the question not only of safety and efficacy, but also the potential horizontal gene transfer and the emergence of irreversible damage to biodiversity or to the environment. And 3, and this was something immediately evident, it raised the necessity for an open and rational discussion, not only to evaluate the safety, but also the values that should support taking risk for the various genomes. And our conclusions were obviously to encourage research. We are research institutions, and knowledge is needed in any way, but a recommendation to prohibit any transfer to reproductive purposes, and at the same time engage broad discussions and open discussions with the civil society. So what is the state of the art of our laws in France at that time? It's clear that we have various types of field. First, gene therapy for somatic cells, and some of you know some seminal works that have been done, but some of them call for attention to safety. For example, the first trials for gene therapy to treat severe immune deficit resulted in a few cases in the rise of leukemias that were solved after by further research, but always we have to be cautious of unexpected results. The second field is the application of genomic techniques to embryos. PGD is allowed for more than 25 years now, and under strict regulation by an agency. And we have 2 different agencies, one for treatments, NSM, and the other one for embryo research and applications. And considering these 2 regulatory agencies, we have also 2 types of rules which define the fact that we have no right to have some kind of attempt to the genome integrity in the view of transmission, in heritability. So we have various articles of our laws that prohibit eugenics or that prohibit some modifications that could be transmitted to the future generations. And so we have two kinds of laws that apply either to research on embryo, but at the end of this research, the embryos are destroyed, or to ART. And in the field of ART, it's prohibited to make any kind of design or any kind of cloning, and also any kind of transgenic or chimeric embryos. This results from the fact that France signed and ratified the Oviedo Convention, and you know that in Article 13 of this convention, you have the prevention of any attempt or any modification that could be transmitted to descendant. And also in Article 18, you have the prohibition of creating embryos for research. So in France, the research is only allowed on supernumerary embryos with the consent of the parents. In the framework of our future laws, there is a debate on particularly what is a transgenic or a chimeric embryos, because with the new genome engineering techniques, this is more blurry than it was, and we have to fight against some activist associations that try to use the ambiguities of the law to prevent any kind of research on embryos. We also have to discuss other aspects, such as the number of days in vitro for embryo research. We need to have an open discussions on Article 13 of the Oviedo Convention, because if some days with safety and accuracy, it's possible to fight against very severe diseases, such as, for example, Huntington's disease, could it be an insult to humanity of eradicating such devastating diseases? And this resulted in several opinions of our National Committee, of our Supreme Court, and also the Office of Science and Technology Assessment of our Parliament that were very open to these views. So we will see next year what is the result of the laws. I will say a few words on REACH because it appeared from our opinion in terms that it needed to be enlarged. So it resulted first in a European gathering where more than 20 organizations, academies or research institutions gathered. We then organized several meetings in Latin America, in India, in Africa to gather with colleagues and discuss specific topics. For example, in Africa, we discussed the use of gene drive in the fight of malaria. And finally, this enlarged in a more international organization that was REACH, that was set up last March in Paris. And you can find the various informations about REACH. I will just mention the main goals of this international association that join several of the proposals that were already done by a lot of you. So I hope we can team up and co-organize. We need obviously to foster the science and biology in the same time as an ethical framework. We need to have an inclusive debate. It cannot be only east or west, north or south. It must be inclusive, and inclusive not only considering human alone, but also human in its environment, and some attempt to use genome editing in animals or plants directly concern human health. We need a global governance. It cannot be scientists alone or lawyers alone or ethicists alone. We need to involve all the stakeholders. We need to elaborate ethical toolbox and guidance that could make a consensus like Xiaomei just mentioned and proposed. And all of this cannot be done only through experts, even if we absolutely need expertise and experts, but we need to engage the public, and the number of people of the press at this meeting is very encouraging. Thank you for your attention.
Merci, Hervé. Now I would like to call Mr. Rao, who is from the Ministry of Science and Technology of the Government of India.
Thanks to all academies for the invitation and the organizing committee to have called me for participating in this gathering. I've been dealing with regulations of all kinds for the last 15 years. When it comes to human genome editing, three important words ring us: safety, efficacy, ethics. I think it is these three words that take us further. As far as the regulation is concerned, India is very clear from the very beginning. We have a very old definition which includes deletion, insertion, and process and product. So whether it is gene technology or new gene technology, genetic engineering, so we have enough clarity that all these technologies are regulated by law, and anybody who violates will have punitive actions. Two, there are regulatory statutory bodies at the institutional level, at the central level, a risk assessment body, purely on scientific basis. The middle one, the one which is environmental ministry, when it is living organism, if it is left in environment, they come in the picture. All the clinical trials are controlled under Drugs and Cosmetic Act. Any intrusion in human body is defined in that act as drug. So under these two laws, entire human genome editing, plant genome editing, microbe genome editing, animal genome editing, everything is regulated. So some of the points which we are debating at the moment is how to actually regulate genome edited products across the organisms under the existing law. So what we did was we appointed three major committees, a committee to just articulate the policy through interministerial consultation and stakeholder consultation through a pan-government approval body. And we have an apex committee to set the principles of regulatory policy, and within those principles, work out the data requirements for human genome editing, plant genome editing, and animal genome editing. We are also very conscious about a white paper on biosecurity implications under this structure. Now, the concept of regulating principles of risk assessment, we have been debating. First thing is understanding process complexity, product features, and distinguishability of genome editing technologies from that of spontaneous mutations, chemical mutations, natural mutations. And in doing so, we find that the red side indicates that most of the resemblance with genetic engineering technologies, where the complexity of gene modification, number of genes that are modified, number of bases that are modified, will tell us whether the risk assessment has to be complex or not. The second diagram says, in evolving these concepts, off-target unintentional effect, successive rounds of modification, major changes, adverse changes in expression profile, major changes leading to increased virulence, environmental fitness, etc. They are taken into consideration while doing the data requirements in conceptual pattern to assess the risks are high or low. The third one is a very evolving concept. This concept depends on the intensity of risk level. We are building a risk level matrix so that everybody is not subjected to every type of regulatory stringency, whether it is single base pair change or change in insertion of many few base pairs, or whether it is distinguishable from the naturally occurring comparator, whether the modification is very complex, leading to multiple attributes, improvement of traits, completely distinguishable from the existing traits, whether the characteristics of molecular mechanisms of programmable nucleases, what are the category of genome editing, what are the delivery methods, what is the predictable program, whether there are predictable outcomes and consequences, intended modifications and efficacy of the change, level of off-targets and consequences. These all are taken into consideration to build a matrix where the green to red movement takes place in terms of risk assessment. This is a very evolving one. Probably we will have a separate diagram for each of the organism. For human genome editing, there may be more different system, but this is at this stage of evolving. So what we have done is we have been presenting these concepts at various forums from 2014 onwards. These red ones are international meetings and several international meetings. We found that we have been getting a lot of inputs by mails and by other processes. We are even publishing on the invite in a cell biology paper to have debated these concepts of risk assessment. But meanwhile, we have already said go ahead with the research area by releasing a new guidelines for R&D of genome editing organisms, including humans, through a new, this was released in UN headquarters, which includes all organisms regulations. We have to inform to the institutional biosafety committees in some cases. In some cases, you have to get their approval. In some cases, you have to also go for the apex bodies at the national level to get under the law the permission. Meanwhile, the Ministry of Health and Family Welfare has come out with new guidelines, well consulted for 3 years, almost 7 years, and these cells say somatic cells for therapy and gene therapy with some conditions are acceptable, whereas embryonic cells only can be used from wasted embryos for research purposes. No more, other purposes are not allowed. These guidelines are available on the websites. They are prepared in consultation with Ministry of Science and Technology and Indian Council of Medical Research. Also notified is the National Ethical Guidelines, which was referred by the moderator, on guidelines for biomedical health research involving humans has been notified. The section ethical review process has been elaborated to help many ethical committees at the institutional level to have no doubt about their procedures to be followed, including stakeholder consultation processes. Ethical committees have diverse type of people in each institution. So there are about 400 institutions who have capable of any molecular biology experiment and who are registered institutional biosafety committees, institutional ethical committees. They are all monitored through a digitized web portal. And now the recent one is being under consultation by the Drug Controller General about clinical trial regimes for somatic cell therapy, including genome editing. This is almost at final stages. As I told you, stem cell or cell-based product means a drug which has been derived from processed cells. So anything which is intruded into the human body, our law says it is a drug. So it defines all the different mechanisms, in vivo, ex vivo, combining with non-cellular component, manipulation of genetic engineering, including gene editing and gene modification. Mind you, all these guidelines have teeth. They are under the laws. So anybody who violates will have a punitive actions. There are various punitive actions, fine as well as imprisonment. Of course, one can go to the court. So finally, to conclude, the regulatory pathway starts from institutes. It has ethical committee, it has a biosafety committee. It has to follow these guidelines, which are on the top, under the law. We are developing major facilities for preclinicals, particularly humanized mouse cells and etc. We have a major transgenic facility coming up, already is in the operation, in collaboration with many other international organizations. Even at the clinical trial stage, another ethical clearance is required, along with for human clearance from the Ministry of Health and Family Welfare. You can't step ahead before without any approval at all, even for the somatic cells. Now, the last one I want to touch is, we have a very bitter experience in furthering the technologies, whether crops, whether microorganisms, anything to do with gene editing, genome engineering. It's all the same for the public. You don't say that it is inserted or it is modified. People take in the same sense. This is a diagram adapted from corporate environmental strategy of Procter & Gamble, where most of the technology is faced in the lack of policy in many countries. The public policy is now being discussed when the damage has already been done. So we are now putting the public policy up front, the one which is the first one, where scientists, academia are discussing in groups like this, interest groups are coming up, some public and media is activists are already entering in this field. So each government should have, at least within their territory, some sort of a broad contours of working in this area across the organisms. So this proposal of policy at the top level in the government is being developed, addressing range of issues. And one attention I want to pay, we are going to have a pan-government oversight agency to regulate, to particularly oversight, not to restrict, but to see where we are going, how to modify the guidelines, where the science is changing, whether we have to revisit all our guidelines. So this policy paradigm is also being a very challenging task. I'm very, very thankful to the organizers for calling me here. I could gather in one day a lot of inputs for this particular policy paper. When it is developed by the end of 4 months, we'll share it with all of you. And finally, I acknowledge all my people. So as a regulator, I foresee that nobody in India can do anything illegal without the approval of so many bodies. If at all anybody does, there are incidences that punitive actions are very severe. They could be imprisonment and fine or both. So thank you very much.
Thank you very much, Mr. Rao. We are now going to hear from Mr. Akutsu, who is speaking from the National Research Institute for Child Health and Development in Japan.
Thank you, Jennifer, and committee members. So great pleasure to having me here to share current regulatory status in Japan. So briefly, my background is OBGYNist and now working on stem cell and reprogramming research, also engaging in bioethical issues. So today I'm here on behalf of Science Council of Japan and as a member of bioethics expert panel of Japan. So I will introduce recent regulatory action in Japan for genome editing on human embryos. So regarding the basic policy on using human embryo for research purpose, actually in this morning, morning session, Professor Kodama presented this issue precisely. So I hope it helped to make use of recognize more deeper. So basic policy on producing human embryo for research purpose, creating human embryo for research purpose is not permitted in principle. It is permitted to use surplus embryos for biomedical research in exceptional cases, but all of the following conditions must be met. First, scientific significance in life science and medicine. The second, the benefits or anticipated benefits are socially appropriate. And third point, assurance of safety for human being. Actually, even if these conditions are met, we have to safeguard must be put in place to avoid concern of reducing human being as a tool. So, based on the basic policy on human embryos for research purpose in Japan, they have 7 regulation and laws. Law is the Act on Regulation of Human Cloning Techniques and 6 other guidelines, probably many guidelines. So guidelines including, for instance, derivation of human embryo, also the guidelines on research on producing germ cells from human iPS or human tissue stem cells. Then, now new guideline will be listed here about human genome editing for human pre-implantation embryos. So we have two main working bodies. One is government side, is an expert panel on bioethics of Japan, has been working on this genomic editing on human embryo based on 2004 basic principle since 2015. Recently, it has just released the draft guideline for research using human genome editing human embryo. Now, just now we have a public comment. So actually, last week we finished up the public comment. So this week or next week, we will have receive the final report of public comment about gene editing issues. And independently, Science Council of Japan in July 2016 started discussion by a committee of specialists on issues related to medical research and treatment that applying genome editing to fertilized human embryos. Having total 12 meetings and two public engaged symposium. So last year, the recommendation, the Science Council of Japan released the recommendation genome editing technology in medical science and clinical application. So I will, in the last couple of slides, I will introduce the summary of the draft guideline and the recommendation for study using genome editing technology on human embryo in Japan. Actually, both of them is a core part of the guideline, and the recommendation is quite similar. So first is clinical use definitely prohibited. It's not allowed. So following the main reason is several main reasons. Actually, in this morning session, so we have to the discussion is so much. Not only the technological issue like this risk of off-target effect and the mosaicism mutation, and the inability at the present to predict the impact of the genetic modification on other genes, and the concern of the impact across generations. Also, ethically and socially concerns not fully debated in our public in Japan. The second part is the guideline. It opened for research, basic research purpose, human genome editing on human embryos. That research purpose is elucidate the function of genes in early development. So I just introduced 3 points. The new draft guidelines include the surplus embryos must be used. It's not create new fertilized embryo for research purpose. And handling period of human embryo must be limited to the early embryo stage prior to primitive streak for day 14 regulation. And the human embryo used in research must also be disposed in a secure manner. Also, this is last slide. So other comment, here is another comment on the guideline. It can be approved that any clinics at the present times, the panel left open to acceptance of basic research, encouraging debate in the research community and the general public. The panel will strive to continue finalization of the report incorporating with related government ministry and agencies. And our ethical guidelines in Japan are also similar to soft law, but have some sanctions. For instance, researchers who violate them are required to repay the research fund they received also, or maybe barred from qualifying for future grant in at least 5 years. So this is just a short report of new guidelines of human embryos. Okay. Thank you so much for your attention.
Thank you very much for this very recent update, indeed, of what's going on in Japan, Mr. Akutsu. We'll now hear from Diane Nicole, who is speaking to us from the perspective of Australia, and she's from the University of Tasmania.
Thank you. So I'd like to thank the organising committee for inviting me, and I'm just so delighted and honoured to be here. So I'm going to talk about the Australian context, and you'll see that compared to the other countries, Australia really has quite a long way to go in developing clear strategies relating to genome editing. And this is interesting because it's despite the vast array of really interesting research that's going on in this country. So I've just drawn from the work by Asasi, Kleiderman and Noppers, examining the regulatory environment globally for genome editing and for other aspects of embryo research, to highlight that Australia, as you can see, is at the prohibitory end. So Australia and other countries are in dark orange, which means that in the regulatory landscape, they're at the far prohibitory end. The light orange is in the middle, and blue is the more permissive. So what happened in Australia, in the early 2000s, there was concern, of course, about reproductive cloning, but at the same time, it was recognized that embryonic stem cell research was developing, so we had to find a way to balance these two extremes. So I want to show you what real prohibitory legislation looks like by illustrating our Prohibition of Human Cloning for Reproduction Act. And you'll see that there are, hopefully you'll be able to see this, it creates a series of offences for things like creating a human embryo for purposes other than achieving a pregnancy, creating an embryo by fertilization that contains genetic material of more than 2 people, making heritable changes to the genome, creating a chimeric embryo and importing or exporting any of these. And the penalty is 15 years imprisonment, so really significant penalties. At the same time, we have another act, a twin act, which is for research involving human embryos. So this creates a permissive regime for some forms of research involving human embryos, and it creates an embryo licensing committee which licenses those types of research. I should note that I've just been appointed as chair of that committee, but I'm speaking very much from my own personal perspective, not on behalf of the committee or the government. what that does, similarly, it creates other offences for doing things with embryos that aren't licensed. So, for example, it similarly restricts use of embryos to excess ART embryos or embryos that are unsuitable for implantation. It creates offences for uses of human embryos created for other purposes unless under a licence, and so on. And all of those have 5-year imprisonment penalties, so really significant prohibitory penalties for these sorts of things. Both forms of legislation required a review after 3 years. And in that review, the first review was in 2005, and that opened the door for limited forms of somatic cell nuclear transfer research. Again, this had to be done under license. That review also said that there needs to be another review in 5 years' time. And in 2011, the second review was undertaken, and further suggestions for amendment were made, but they weren't implemented. It wouldn't have changed things that significantly anyway, but that ended the compulsory review process, and as a consequence, there haven't been any other reviews of this quite significant legislative regime in Australia. In 2018, the upper house of the Australian Parliament, the Senate Community Affairs Committee, looked at the specific issues around mitochondrial donation and related matters. Because again, it's not possible to do mitochondrial replacement therapy at the moment in Australia, and there are limitations on the types of research that can be done. The committee recommended that there should be a further consultation paper on options reform, and there should be extensive community consultation and further advice on whether a distinction should be made between mitochondrial donation as distinct from germline and genome editing. So you can tell in Australia that there is a long way to go before there's likely to be any reform of the legislation, importantly, and I think necessarily requiring extensive community consultation, but not just that. There'll be other things to do before we see whether there is a view that there should be amendments to the legislation. I want to turn briefly to somatic cell gene editing as well, because there are issues there. Obviously, you'll be aware that the US National Academies said that existing regulatory infrastructure and processes were adequate in terms of reviewing somatic gene therapy. But in a paper that was published with a group of colleagues who met in Hobart back in 2016, where we discussed some of the issues relating to somatic cell therapy, we cautioned that there were some major challenges for clinicians, regulators, and human research ethics committees, or IRBs if you prefer, in the clinical translation of CRISPR-mediated somatic cell therapy. And I've just highlighted some of these here in an upside-down triangle, going from I guess, the more global regime through to the very specific patient level. So as soon as this moves into the clinic, obviously there'll be issues with the patent landscape, so it will have to be thought through whether licensing is necessary and what form that licensing will take. In terms of the gene technology regime, obviously that's relevant in many countries. In Australia, somatic cell therapy involving humans is specifically excluded. So although there has been some policy development in the gene technology front, it's not relevant in terms of human somatic cell therapy. But it would be if there were viral vectors, because of course they would need to be licensed. Health technology assessment, there hasn't been any real discussion as yet about the health economic perspectives of somatic cell therapy. And I think it will be important to have those discussions both in Australia but also more globally. Product marketing approval is also an issue. Our Therapeutic Goods Administration, I don't think, is as far advanced in these discussions as the FDA. So we don't know questions like whether it will be necessary to get approval for each CRISPR construct, or whether, for example, it would be possible to get approval for classes of constructs. Research and clinical ethics. Research committees are going to, I think, struggle a little bit with expertise in reviewing these types of proposals. And then we get down to the individual clinician. Obviously, it's for the individual clinician to make the call on whether this technology is ready to go into human beings. And they will be guided by all of these regulatory requirements, but also professional codes, and of course, peer review. What their peers think of this will be a really important determinant. And finally, at the level of the individual patient, consent is going to be pivotal. And as many of these patients will be children, it becomes even more complex, and it might be necessary to go to the courts or to guardianship boards to determine whether consent should be granted. So a lot of complexities here, and I and my group think we need to look more holistically at the whole package of how somatic cell therapy is to be regulated. So in conclusion, Australia's current regulatory approach to germline genome editing is highly prohibitory. Genome editing embryo research also appears quite difficult to license in the present form. And there are also a number of regulatory uncertainties for somatic cell genome editing. Reform, should it happen in Australia, is clearly going to take some time to achieve. Thank you.
Thank you very much, Diane. And we will now hear from Ms. Tamra Lisak from Singapore National University.
Okay, all right, thank you. So first of all, I would like to thank the organisers for inviting me and for the sponsors for their wonderful hospitality received so far. When I got the invitation, I wasn't really sure what I was supposed to talk about, so I've just crafted my presentation to sort of fit broadly within the theme of this panel. Now, I'm not a regulator or a lawyer, but I can speak in my personal capacity as an academic scholar from the National University of Singapore about government responses to genome editing technologies in Singapore. I can also talk about a project that we're about to launch at the university to help nudge some more specific responses to the technology, and also some of the activities I've been involved with in my capacity as Vice Chair of the Committee for Ethics, Law and Society of the Human Genome Organisation, which has recently published some opinions on human gene editing. So just to give you a brief overview of what has been happening in Singapore, it is fairly limited, and it is likely because scientific interest in the area has been quite limited. From what I've been able to ascertain, there is some research, of course, going on in food and crop science. I've seen some, some small projects up and running with disease modelling with iPS cells. The SynBio guys are doing some work with genome editing technologies, although not in human systems, from what I can tell. And there is also now some interest in the gene editing for hematopoietic stem cell transplant therapy. Of course, I don't know if that's been funded yet. In terms of using CRISPR for germline modifying applications in human embryo research, I don't know of any research that is either being proposed. I don't actually know any scientists who are interested in doing it, and so that probably explains the limited responses. That may change, of course, especially in light of recent events. Of course, if there was to research to be undertaken in this area. Besides the legislation, the laws that Singapore has recently introduced that cover all biomedical research with human subjects, and that includes human cell lines and, of course, human embryos, which would require both a ethics approval from a institutional review board, ethics committee, in addition to approval from the Ministry of Health. They would also, if there was any genetic modification, they would be falling under the narrow remit of the Genetic Modification Advisory Committee. Now, this committee is not it doesn't have any statutory authority or powers, and again, its scope has been quite narrow so far, at least. It has only issued 2 guidelines, both of which are non-binding and both of which are fairly narrowly focused on biosafety issues and risk assessment, both with respect to using biological entities which have been genetically modified in human research, in addition to the import of those products and the potential release of agricultural products into Singapore, GMO related products into Singapore. And I couldn't tell you if any of those have actually been released in Singapore either. It is worthy to note that both of these guidelines are not technology specific, so none of it is specific to any of the tools, the technologies that are used. So there's no specific guidance, for example, for CRISPR-Cas9, and I'm unsure if it would be necessary. But moreover, yeah, again, I sort of draw attention to that these are quite sort of narrowly focused on sort of biosafety issues about, with respect to public health and environmental hazards, rather than safety concerns for any children or indeed sort of animals that are generated as a result of germline modifications. So this is where we are kind of coming in to help maybe fill a void. We have a project that's funded by the National Medical Research Council under our program, which is called Science, Health and Policy Relevant Ethics in Singapore, or SHAPES. We are convening a working group of local and international experts to identify substantive and procedural values that should guide genome modifying technologies within an ethical framework. This project's going to kick off next year with a symposium in April, and we hope to release the framework in 2020. So if anyone's interested in this, please come up and talk to me in the next couple of days, or you can contact me through my Twitter account. Now, without preempting the type of values and considerations that this working group might be looking at, I again mentioned that I was on the Committee for Ethics, Law and Society, or CELS, of the Human Genome Organisation. We have half of the committee is going to be on this working group, including Professor Ruth Chadwick, who's going to be co-chairing it. Last year, this committee published a paper expressing opinions, our opinions on some of the ethical issues of CRISPR technology and gene editing. This paper sort of followed from actually the first International Summit on Human Genome Editing in Washington. And basically in the paper, we agreed with the concerns that were raised. We certainly supported the opinion that somatic applications of the technologies were to be encouraged and acceptable. However, we also agreed that it would be irresponsible to proceed with clinical use of germline editing unless and until relevant safety and efficacy issues have been resolved. And they noted that at the time, these safety issues had not yet been adequately addressed, and that there was also limited compelling benefits to justify germline therapy. So again, we agreed with these concerns. We also went a little bit further in our support for calls that were being made at the time for a moratorium on experiments with CRISPR-Cas9 that are aimed towards germ cell mutations. Now, just to be clear that this is not a formal position of Hugo or even the committee. They are the opinions of members on the committee who published this paper. We do hope that Hugo will be issuing a formal statement next year on the technology whether or not such a moratorium is feasible in light of the news in the last 24 hours, but we will see. So again, and the concerns that we were having is not just about the safety, but also the potential misuses of the technologies and ensuring that any benefits that can be derived from it are widely shared and are not, don't become the exclusive property of a few. And this is where we think that values must come into play in order to be able to guide us as a human community in our decision-making about where to take this technology. If the hype about CRISPR is true, and I'm still not sure it is, but if it is really this disruptor technology that's set to change the world, then perhaps we should very carefully consider how we want to change the world with this technology to ensure that these changes align with our values and they are for the good and don't leave us worse off. So, for example, if we value fairness and equality, then we should assure that everyone has access to the health benefits of the technology and not just the wealthy whose opportunities to gain further social and economic advantage will be promoted because they can maintain good health. Now, to achieve this outcome, we need to guide technology towards generating products and applications that are accessible and affordable to all those who need it. If they are not, then we potentially arrive at a situation that exacerbates existing inequalities, and this situation would be unjust and thus morally indefensible. For this purpose, an anticipatory approach to science governance may be useful to encourage responsibility in how gene editing technologies are developed. This approach, which has transformed into the framework for research, responsible research innovation, which probably many scholars and scientists in the EU would be familiar with. It is aimed at shaping emerging science-based technologies to deliver outcomes that are both socially acceptable and are morally justifiable, while it is still possible for us to have any influence over the direction of the technology. So with the news of the last 24 hours, assuming those claims are true, it suggests that the time frame and the opportunities to be able to shape the development of gene editing technologies is getting narrower, and there is more urgency to reflect on what sort of world we want to create for future generations who may benefit from the use of these technologies, but will almost certainly shoulder the burdens of decisions that are made in the present. And for that, we do need a coherent set of normative principles and values to guide these decisions, and that this framework should be informed by deliberative democratic processes of participation, inclusion, and reflexivity. And with that, I will just acknowledge citations I've referenced. Thank you.
Thank you very much, Tamara. We'll be talking more tomorrow about these various ideas of public engagement and how we can envision this in the very near future. Last but not least, we are now going to hear from Mr. Lot Chan, who is at the Department of Health here at the Government of Hong Kong. So he is, as a sort, our host. So I ask that we welcome him. Mr. Chan.
So thank you, and I think I should say welcome to Hong Kong, and good afternoon. So because I'm from the Department of Health, so what I'm going to do is to highlight two aspects in relation to the topic today and from the perspective of regulators. So the first aspect I would like to share is about the regulation of advanced therapy products in Hong Kong, which we have been discussing for the past few years. So from this slide, you will see that we have started the discussion in 2012, and then we have set up a task force on the regulation of advanced therapy products end of last year, from which we have developed a proposed regulatory regime for advanced therapy products early this year, and we started a public consultation. And also we have just issued a consultation report last month. So after the consultation, we received lots of support from the public. So we are now in the process of developing and prepare the necessary legislative amendment so that we could regulate advanced therapy products under the existing regulatory regime for pharmaceutical products. So for advanced therapy products, we basically absorbed the EU's definitions for ATMP, which consists of somatic cell therapy products, tissue engineered products, and also the gene therapy products. So this is the gene therapy products which would be relevant to our topics here. So this is a kind of copy part of the definitions for gene therapy products from the EU regulations. This is not the final for the Hong Kong legislation, but it basically spell out the scope of gene therapy products. So for example, gene-modified somatic cell therapy products will be considered as a gene therapy product. Adeno-associated virus containing CRISPR-Cas9 and guide RNAs to be administered to a human being, targeting a specific gene for the purpose of preventing or treating a disease would also be considered as a gene therapy product. So in other words, these products will be regulated as pharmaceutical products in Hong Kong. So currently, pharmaceutical products are regulated under the Pharmacy and Poisons Ordinance in GIST. So these kinds of products has to be manufactured by licensed manufacturers who are fully comply with the good manufacturing practice. People want to conduct clinical trials of these products would require prior authorizations. And also, if you want to market some this kind of product, need marketing authorizations. There would be also some import and export control on these products. So basically, the regulations of these gene therapy products or pharmaceutical products will be similar to that of medicinal products in other jurisdictions. So this is the first aspect. So the second aspect, it will be the regulations of embryo research. In Hong Kong, we have a piece of legislation called the Human Reproductive Technology Ordinance, which regulate the reproductive technology procedures and also services, as well as embryo researches. So if research involving the creation or cloning of embryo, or combining human and non-human gametes or embryos would be prohibited under this ordinance. If someone wants to carry out a embryo research which are not prohibited by the law, must obtain a license from the Council on Human Reproductive Technology. So for this Council on Human Reproductive Technology, they have promulgated a code of practice under the authorization of the ordinance, providing the requirements and guiding principle related to reproductive technology as well as embryo research. This code have a small sections in relation to the genetic manipulation. So the code provides that any research involving the modifications of the genetic structure of gametes or embryo must first be approved by the respective institutional research ethics committee before submitting to the council for a license. And also, any intervention or research seeking to modify the human genome may only be undertaken for preventive, diagnostic, or therapeutic purposes, and only if its aim is not to introduce any modifications in the genome of any descendants. In addition, germline gene therapy should not be performed. So, of course, the code is very comprehensive, and I only highlight a couple of points that are of interest because of time limitation. And that's all I'm prepared to share. Thank you.
Okay, so I invite all the speakers to come up and take a seat. I just want to make a preliminary comment. We had 7 geographical snapshots of regulatory practices, and though they were different, there was one thing that they all shared, and that was the prohibition of using human germline modification for purposes of reproduction. And I think that's a consensus that all of these 7 geographical areas have come to on their own, within their own national contexts, and within their own national cultures and debates. And I have many questions, but I think I'll let people from the floor first ask their questions.
Thank you. So, Robin Lovell-Badge from Francis Crick Institute in London. Can I just ask a question, probably for most of you, really, because it's very apparent that in some countries, embryos can be created specifically for research, but in many countries, you're not allowed to do this. That includes many of the countries represented here. Clearly, if you're going to do research which is, I guess, more relevant to eventual clinical applications, or even just research to understanding early human development, you need to use the most efficient methods possible, and perhaps that's going to have to include introducing the genome editing components at the same time as sperm. So you'll have to create embryos for research. So just like your views on whether you think these things could change in your countries, is it an intractable problem?
Yes, I'd like to hear from each of you on that particular question. So beginning with you.
So creating embryo, yeah. So we have one guideline so far. So it is allowed to create human embryo using surplus gametes, but only research purpose for reproductive medicine issues. That is only one. However, just a draft guideline for human genetic editing, it's not allowed use creating embryo. It's still ongoing, the conversation with the government or social issues.
Robin, you know perfectly that this discussion took place in the framework of the discussion at the Council of Europe, and then resulted in the Oviedo Convention with Article 18. And till now, it's mandatory to respect this for the countries that ratify. So France continue to prohibit creating embryos for research, even if many of us, we know that it's in some ways hypocritic. For example, new peoples that have to be trained for IVF need to be trained a way to do the good way before going to the practice or to be licensed for the IVF. But it's the difference between the principles that apply, for example, for research, and the real life where you have to make some compromise with the principles.
Thank you very much for your question. So in Singapore, there is no legislation that would prohibit the creation of human embryos for research. There is the only the documents that would be relevant are reports that were issued by the Bioethics Advisory Committee, which falls under the Ministry of Health. In that report, they have recommended, the use of surplus embryos from IVF for research, but have discouraged, or have said that there wasn't sufficient justification for creating this for research. This report is now back in 2002, and while it is not legally binding, the government has always taken those recommendations quite seriously. Of course, all human embryo research, as I mentioned in my talk, are now falling under it's called the Human Biomedical Research Act. And if you wanted to create embryos for research, yes, you would first have to get a IRB to approve it, and then you would have to go to the Ministry of Health for an approval, and it would be up to the minister's discretion as to whether or not they allow it or not.
I just want to clarify that in legal terms, in India, there is a law, there is a rule, there is a regulation, there is a guideline. These are all different terminologies. The law is made by the lawmakers, parliamentarians. Rules are approved by the parliamentarians, not discussed by them, under the law. Then in India, regulations are made by the regulator, which a part of it I showed, that we finalize the regulatory system, but the guidelines are based on those regulatory principles. The guidelines always are flexible, because the dynamics of science, considering the future growth of science, we kept open the guidelines, and any deviation in these guidelines, there is no word like ban, there is no word like moratorium in those guidelines. So anything deviation, if it is ethical issue, you have to represent to National Ethical Committee, or you have to, if it is something to do with safety, you have to refer to another body. That is the system we go, and guidelines will change every 2 years maybe.
So the creation of embryos in Australia. Yeah, thank you. And we have the same regulatory system in Australia as India. But of course, in our laws, it's quite clear in the legislation that you can't create an embryo for a purpose other than achieving reproduction, pregnancy in a woman. To change that law, I think it would be really quite difficult in Australia. There is a very strong view that the embryo has a special status. Indeed, when the legislation went through in 2002, it was the longest, I think the longest ever parliamentary debate just to get that legislation through to allow certain uses of embryos for research purposes, but only if they're XSART embryos. So it would be a very big step for parliamentarians in Australia to make that move. It would require very clear community consensus. And there certainly are views in the community in Australia that would support research involving embryos, but whether there would be sufficient consensus to persuade Parliament to act is another matter, I think.
Yes. According our, I think the ethical principle is we can use for research only the spare embryo from IVF centers, but now we're still in the discussion about such as IPS, from that way. So we don't have the very clear regulation about that.
Thank you. As I just said, our law prohibits the creations of embryo for research purpose, so embryo research has to be done on the donated embryos from excessive embryos, and because it's in the law, so I don't see that it's easy for us to change that for the moment.
Earlier today, Dana Carroll from the University of Utah. Earlier today, Dr. Chu lamented the fact that there were no penalties in China for disobeying guidelines, I guess you would say. I wonder, in any of the countries where there are penalties, India, Australia. Has anybody been prosecuted under these? Has anyone suffered a penalty for violating these laws, regulations, rules, or guidelines?
I'm pretty certain that there never has been a prosecution under Australian law. I would imagine that the mere fact that those provisions are there has discouraged anybody from undertaking that sort of research or therapy.
Yeah, in India, in many incidences of GM crops, there have been punishments. But in case of health research, of course, many companies have been given warning and some registrations have been cancelled.
Our law has provisions on the penalty, so the maximum penalty is 2 years imprisonment, and also a fine of 100,000 Hong Kong dollars. I'm not sure about whether any prosecution has been done because I don't have the statistic on hand.
Anybody else?
So in Singapore, pretty much all statutory acts are attached to the penal code. So although the Human Biomedical Research Act, which covers human embryo research, has only been in effect for about 2 years, I would not expect that anybody would be prosecuted under that because in of itself it's a discouragement, as we see with most of the acts in Singapore being attached to the penal code. The implication of that is, though, it's not just going and doing kind of these way out there experiments, you get the consent form wrong and you potentially have violated the act.
Mr. Akutsu and Mr. Akutsu, have there been prosecutions in Japan?
So about genome editing guidelines before launching, so nobody violated. So other guideline, regarding other guideline is fortunately, so nobody violated the guidelines.
I should say that in France you need so many licenses to use gametes or to search on embryos, and it's under such a surveillance by our Agence de la Biomédecine that no one should go because the license should be removed immediately. So to the best of our knowledge, there is no such research or no such infringe. And thus, if you want to publish such research, you need an IRB number, and you are immediately trapped if you go ahead of the red light. So I think that the main consequence is that many researchers refrain from this kind of research, and now you see the development of many research on embryonic entities that are much more recombinations of naive stem cells plus trophoblastic stem cells. You have new embryoid entities, and this kind of research on 3D embryoids are rapidly developing, and I think that the main trains will go more on these new entities than on real embryos.
Okay, so you had a question.
Yes, thank you. Tiak Fayal, Nature Genetics. I was wondering if you could comment on whether the laws, guidelines, rules in your respective countries explicitly talk about the possibility of somebody going abroad and practicing or making use of technology that is illegal in your countries and then come back into the country, let's say, with a genetically modified human embryo. And I mean, and you can imagine various scenarios as a surrogate, as going abroad and using IVF technology and then coming back. Do your laws explicitly take into account this possibility?
Can we begin with you, Mr. Chan? So cross-border medical practices or research?
It depends, because if part of the research is taking place in Hong Kong, then you'll be under the regulations. But if the research is totally carried out outside Hong Kong, then it would probably out of our jurisdictions.
So,
The question is if research is taken, research that is prohibited in one's country, if it is carried out in another country.
就是 some trafficking, something like that.
Yes, is that mentioned in your regulations guidelines?
Yeah, so far I don't think we have this special article about that.
Whereas in Australia, it is clearly mentioned that importing or exporting embryos that have had any of these things undertaken to them is as much a crime as doing the offence itself. Of course, it might be different if a woman achieves a pregnancy elsewhere and comes back into the country. I don't think that sort of circumstance would be covered, but certainly bringing back an embryo that's been modified in some way would be an offence.
It is similar to Australia, but you see, most of these are territorial regulations. We have no right to inspect how he has done. So even in drugs, territorial, most of them are territorial. Under certain circumstances, the exchange of data exchange takes place, and the regulator comes to accept this. Otherwise, it is never accepted.
All right, so I'm not a law scholar, so I can't comment on the specificities of the Human Biomedical Research Act, but my understanding of it that certainly the items that cover procurement of cell lines or embryos, that they would apply to entities imported from overseas. And the GMAC, the guidelines that it has developed or issued does cover the importation of genetically modified organisms, which would include a cell line or an embryo. But again, these are not legally binding. So.
The answer from the law in France is yes, and it was already done for people in the field of human stem cells. But now you have the European regulations that says that if something is allowed in one of the European countries, the practice is allowed. So, for example, a French researcher that should go in Belgium and create embryos in Belgium and study them in Belgium should not be prosecuted in France if this researcher is not bringing back the created embryos this way. If all the research is done, for example, in Belgium, the guy will not be prosecuted. If part of the research is done in France, there will be a prosecution.
But Hervé, my question a follow-up question is, if he does this, a French researcher, if she or he does this, studies a created embryo in Belgium because it's allowed, can she or he then publish his results in a French journal, French scientific journal? Has that happened?
If it's done under the IRB and the regulation of the countries that allow the research, for example, in UK or in Belgium, there will be no problem. Now, if part of the research involving the created embryo is done in France, or if any parts of some cells are imported in France, there will be a prosecution from the French laws. So this is the fact that the European laws are above the French laws.
But sorry, I meant specifically for reproductive purposes, not research.
Sorry,
for reproduction, not research. The creation of embryos abroad for reproduction, not research. That was the question.
So yes, I was speaking for research. Oh no, for reproductive. you cannot use for reproductive purposes any embryos that have been submitted to any kind of research. This is a more general law.
I'll give a very specific example. A couple wants to modify their offspring. They can go to another country where there are no restrictive guidelines in place. They will undergo an IVF treatment. The couple will return to France. The woman is pregnant.
It should be It should be a real novel case that didn't happen yet, but we could try to see some example from surrogacy, which is prohibited in France, and all the couples that came back in France with the children obtained by surrogacy were prosecuted and had very great trouble to make the child recognized as their own.
Yes. Reproductive clinical use, so go abroad issues. So in Japan, we cannot stop such a patient go outside of Japan to something making, for instance, the fertilized embryo and back to Japan. We don't have any regulation stop such a clinical use.
Okay, thank you. Yes, thank you. Kazukato from Osaka University. In the session this morning, Professor Chu from China was talking about possible benefit of relying on United Nations discussions about this kind of activities. So, inspired by that, my question to the panel is, well, yet you have so diverse regulations. So my question to the panel is whether there is any benefit of having such kind of global dialogue or maybe mechanism to discuss these or think about these regulations across the countries. If there is any, I mean, what kind of things do you think of?
Can I add a following question?
It's the same, yeah.
Similar, yeah. I just want to follow the question. And then first of all, I have some kind of complaint about why the panel didn't include United States, because it's a because it's organized by the NIS, and so and then if it is a regulatory update, I wish to hear about what's happening in the United States. It's a huge country like China, India, so and then their technology is quite advanced. And the two, field reports that China and the United States will lead the germline modification technology. So I have a complaint. Why not include it? The USA in this panel. And the second of all, if we have ever talk about the regulatory framework, what about the possibility of harmonization of the regulation on this matter? If it is very important, what's the result of the organizing committee at the end of these 3 days of summit?
I'm just going to answer for one of the questions, and then I'll let whoever wants to answer the other part. I didn't quite understand your first complaint. I understood, however, what Kazuto was asking. Insofar as the United States not being represented on this panel, is that what you were saying? I think one of our objectives was to, because of the 2015 summit and because of the report, there was a lot of Anglo-American input and information provided on regulation, and the report indeed really covered all of those bases very thoroughly. And I think that our objective was to just displace the way we are looking at these issues and look at them from another part of the world. And that's why we came here, and that's why Hong Kong, in fact, welcomed us. So I think it's not a deliberate, it wasn't a deliberate thing that we did. It was part of a process that began with the first summit and that I hope will continue with subsequent summits, that is to go to different geographical areas. Now, for the other question, who wants to take up Kazuto's question? Or
not all of you don't have to answer. Anyone willing?
So, the question you were asking was, can UN deliberate?
No, it's not necessarily about UN, but about some kind of global, wider dialogue.
Actually, we do have such consensus documents in other regulatory paradigms. For example, OECD does a lot of oversight harmonization. In fact, I attended some of the meetings on genome editing. And also there are special purposes in case of Biological Diversity Convention. They do harmonization documents. But the experience has been, I have been attending for last 15 years these type of meetings. The experience has been that anything legally binding at global level is never been effective. What is more important is most of the countries search in the web for some consensus documents. I mean, large consensus. There are areas where there could be large consensus. There are areas where consensus are difficult. So I think consensus documents, which OECD usually refers to, I think in this area would be very useful with the required caveats for territorial modifications at global level.
Yeah. Ernest, my name is Ernest Winacker from the German National Academy, Leopoldina. I want to come back or return to one aspect which we discussed a couple of minutes earlier, the questions of penalties and what happens if a researcher from one country where things are prohibited goes to another country and then does particular research which is permitted in the other country. One aspect in our surrounding, especially also in European surroundings, is where the money comes from. Just one example, in the European Research Council, which of course is an instrument which actually funds research for anyone who applies around the world, in the European Research Council, its decisions are completely independent from politics. So, but there's one exception, and this is research with human embryos. And whenever an application arises and is approved by the science, by the review committees, the various review committees, then in this case it goes back to the national contact points. And then most of the time Germany would say no, because and then nothing would be funded. But it's only this particular aspect which is really very complicated and was very difficult at the outset of starting the European Research Council. So and in Germany too, we will hear tomorrow from Dr. Friedrich, if you take, you are not permitted to take German money to any country where the legislation is less restrictive than in my country. That is illegal. And so there are some aspects which I wanted to mention here, which are related to the funding situation and where the money comes from, with which you go into another country or things like so one should not forget these kind of funding restrictions. Thank you.
Elvi, did you want to say something about that?
I perfectly agree. Just to get back to the previous question, I think that in the panel I saw a lot of consensus, even if we have different regulations, but we have different histories, we have different values, as you see even in Europe with countries that try to unify in a European community, we have different regulations because it's a very sensitive subject. And it's normal that specific values, including, for example, for Germany, history, that has some relationships to eugenics or to attempt to embryos are making the regulation different, and it's intermediate in France and it's more liberal in the UK, which will not be in the EU more, but that could have been. So the values are different, so it's normal, but many consensus exist. I think that the prohibition of manipulating embryos and then trying to give birth to a baby is at that time prohibited in most of the countries. And this is why we are so critics in front of what happens in the last 24 hours.
So Mr. Rao will say something, and then we have time for one last question, and we must stop after that.
I just want to say that the whole regulations ethics are evolving actually. There are many debates around this. I mean, in the early days of drug discovery, we had the same thing in many of the drugs. Today, we accept all the GLP data across countries. We also accept certain of the clinical trials, for example, HIV-related vaccines. Some clinical trials are accepted from other countries. So I think maybe in the future, these questions become relevant.
And your question?
Okay, thank you. I'm Sun Ye from the University of Hong Kong, and my question is, you have so many laws, rules, and regulations right now, and I think researchers in academia, they will probably respect such regulations. But how can you prevent some like crazy rich billionaires or crazy rich people like Elon Musk to do such kind of genome editing in his own privately funded lab? So can we stop him before like such things happened? Yeah.
I just wanted to say, relative to that question, there's going to be a discussion on rogue scientists tomorrow or the day after. I can't remember. I use the term as it is used in the press. But does anybody have anything to say about that?
So you're talking about microorganisms?
Mm-hmm.
Manipulating microorganisms?
No. Like he just wants to do the research for himself or his private purpose to reproduce some super people with genome editing technology. No public funding needed because they are crazy rich people.
So I think there will always be that risk of the buccaneers, or whatever you want to call them, who can find their own private paradise. What is it, Dr. Morrow's Island? Yeah. So there's always that risk, and it's really impossible to guard against, other than I guess social prohibition. So the power of the media is really important in this regard, I think. So I hope there are still some media people here who listen to this and recognize that the media has a really important responsibility in this regard.
I mean, there's one example in this respect, is that cloning, human cloning, could have been done since Dolly or so, but it was never done. So as far as we know, it was never done. And it is probably cheaper than what we are talking about here. And so nobody wanted to try to do this with all the money in the world. So maybe you are safe.
Okay, thank you.
I was just going to just an observation to follow. I think it's going to be very hard to control, the biohacking community. I think that is a real concern for regulators everywhere. But when I sort of look at this issue, and it looks quite similar to what we've seen with the stem cell therapy phenomenon, is that we have actually really quite well-regulated areas for scientific research, and I do think that the far majority of scientific researchers are responsible. We have very good technology regulation. Where I see the weakest area is in professional governance. So, I mean, if the problem is not so much that you're creating, genetically modified embryos in a petri dish and just, to study disease models and so forth. The problem is when you go and implant that into a woman for a pregnancy, and for that you need a licensed medical practitioner. And this is where I see the weakest area of regulation, not just at a national level, but certainly at an international level. And that's going to be one of the biggest challenges in trying to control where the direction of the technology goes as it sort of gets forced into practice way too early.
Okay, well, I think we're going to call it a day because it's been a very long day and an intense one, and we are starting very early tomorrow morning. So thank you all for being here, and have a good evening, and we will see you all tomorrow morning at 8 sharp.